Welcome, entrepreneurs, students, and taxpayers. This is The Tipping Point, a show devoted to individuals trying to get ahead. We scour the region for the most competent individuals in their business-related fields and allow them to educate us on their specialty. Because knowledge is power, and with enough power, you can tip the scales in your favor. I'm your host, Gabriel Velez. The Tipping Point is brought to you by Terrani & Velez, an Irvine-based tax and accounting firm. Today, we have Michael Zingale, attorney and partner at Statina, Brunda, Garrett, and Brucker, a local patent, trademark, and copyright law firm. As a reminder, if you like today's content, please remember to like, share, and subscribe. Welcome to the show, Mike. How are you doing?
I'm doing well, Gabe. Thanks for having me.
Yeah, it's a pleasure to have you. So today, what are we talking about? We're talking about how entrepreneurs and inventors can protect their ideas, right? I mean, that's the crux of the law that you practice, right?
That's what I do. Yeah, all that hard work and creativity that goes into it, we want to make sure that they can protect it and have as much exclusivity to it as we can get them.
Right. Yeah. Especially with these mega corporations out there, they can easily outpower you, outmoney you, right? And so the protection is really important.
Exactly.
Yeah.
Exactly.
Perfect. All right. So before we actually get started into like the specifics of trademark or patent, let's take a little time to explain to the audience what each of these are and how they kind of differ.
Sure.
Yeah.
Sure. All right. Well, we can start with a patent. A patent applies for an invention, and it would give the inventor, or if it's a company who has employed the inventor, it would give that company the right to exclude others from making that product or practicing that method for a period of up to 20 years. So if you've worked at creating a new product, the patent would be something that would give you the right to have exclusivity to that.
Okay, and then trademark?
Trademark, it's a branding tool, marketing, and it is really to protect consumers and the company to make sure that consumers know the source of the goods and services that they're buying. When I see and buy something that says Coke on it, I have an assumption as to where it came from and what it's going to taste like and the quality of a particular product. So trademark would be branding, logos, other indicia that serves to identify the source of goods or services.
Yeah. And then do you do copyright as well? I know the firm does copyright.
Yeah.
But
I do. I have a little copyright practice, and that all falls under the broader umbrella of intellectual property.
Okay.
That intellectual property refers generally to patents, trademarks, copyrights, trade secrets, rights of publicity. But a copyright goes to creative works, books, music, literature, sculpture, photographs, artistic renderings, that sort of thing. And it gives the author of those works the right to reproduce them and use those works for a specific period of time.
Got it. Okay. All right. So let's jump a little bit more into trademarks,
Okay.
right? And so you kind of touched on it a little bit before, but trademarks are primarily for branding and protecting your brand and image.
Yeah, so it's how you really hold yourself out in the marketplace and what consumers see or hear in the marketplace and how they would identify you. So if you sell a widget, how do they know it's a widget made from you versus your competitor? It's your name. It could be how the widget is configured. A trademark isn't just limited to the name, but it could extend to the actual configuration of the product or packaging. And an example of that would be the Coke bottle. You just by saying a Coke bottle, you have some idea of what I'm talking about,
Right.
like a specific shape or configuration, and you associate that specifically with the Coca-Cola company. So it's different characteristics of your product or service that consumers identify specifically with you.
Got it. Okay. And so this brand or this image, it doesn't really matter what industry you're in, right? You can always protect it.
Yeah, exactly. Yeah, no matter what, as long as you're in interstate commerce, you can apply for trademark protection, at least on the federal level. And if you're not a big operation yet and you're not in interstate commerce, you can apply for trademark protection on the state level as well. But in most cases, reach that interstate commerce threshold and protect yourself throughout the country to give yourself the ability to expand and have, those rights protected, not just in your initial region, but nationwide.
Okay. When should an entrepreneur or business owner think about, trademarking something? Obviously, everybody has a logo. Everybody
Right.
has a particular style or something they think looks good. But
Yeah.
when is it worth it?
As soon as possible. I mean, you
Yeah.
can sometimes clients come for the very early stages, and when they do that, we can do a search for them and see if the logo or mark that they're contemplating would be available. And if some of the hurdles that they could face is that there's someone that may have a mark that's similar to what they're thinking of.
Right.
And that could be a grounds for rejection. So if they come early on, we can help them navigate through that and find a mark that would be unique to them.
Mm-hmm.
But if they haven't and they've already adopted a mark and they've been in the marketplace for a while, it would still be a good time to seek out trademark counsel to try and get that brand protected and to preserve your ability to expand, or to just, if you want to go after and start enforcing your mark, making sure your competitors don't do something that encroaches on what you do. So really there's always a good time, or there's never a bad time, but early on would be the best to give you the most options and the ability to, if you need to change course with a particular mark, it's obviously easier to do that before you have, stockpiles of inventory with your brand already on it that might be infringing somebody else's. So this is all clearance type of work that we can do that's easier to handle at the early stages than the later stages.
Got it. So that's a good point that you're making, right? So you might think it's cheaper to not hire an attorney to go out and get a trademark, but you might actually be infringing on somebody else's trademark inadvertently, which might cost you more money in the long run.
That's exactly right. Yeah. So there's two main things that you would keep in mind, not only in the trademark side, but the patent side. One is, can I get exclusive rights to my idea or my trademark? And the other is, am I going to step on someone else's toes? Am I going to create an infringement issue if I adopt a particular trademark, or if I start selling a product that might be patented by somebody else? So our practice includes both acquiring those rights for those individuals or companies, but also providing clearance work hopefully before they adopt that mark or start selling a particular product, to give them some sort of assurance that they're not going to create infringement concerns down the line.
Okay. Most companies, especially when they're getting started, they don't have a marketing department. They're not developing these brands internally, right? They're like purchasing them from a marketing company or a graphic designer or something like that.
Sure.
Who does that belong to? Well, I don't want to get too technical, but like generally, is that something that should be discussed with the graphic designer, who the actual design is going to belong to? Because I know like my wedding photos technically belong to my photographer, right?
Right. Yeah. So that's always a big concern, especially when you're dealing with a company that has several employees that are working on something. And so in that type of situation, for representing the company, we want to make sure that the company is set up and has the agreements in place that any ownership of whatever's being created, whether it's a photograph and it's a copyright that we're talking about, or if it's a graphic designer coming up with a logo, that copyright's going to be transferred to the company, and the company is going to be the one that owns it. Same thing on the patent side. If an employee comes up with a new idea, the general rule is that whoever creates that idea, whoever creates the photograph, is the owner of that. And so you need to have an assignment or some other agreement in place that transfers that ownership from the author, the photographer, the inventor, to the company.
Yeah, and when they're an employee and they're doing it on company time, it usually belongs to the company, right? Usually.
Yeah, but you don't want to rely on, you want to have an agreement that explicitly makes that clear, and leaves no doubt in mind, and doesn't give, a rogue employee some grounds to try and, create a hassle for the company later on.
Yeah, I'm sure you've seen that in the past. So who does this really belong to?
Yeah, exactly.
Yeah. Okay. All right. And so like how novel does an image or like a brand have to be in order for it to qualify for trademark protection?
So there's a spectrum that is generally used when you consider trademark protection and whether a mark is protectable or not. And on one end of the spectrum, you have what's referred to as generic marks. And those marks have a high degree of, they're used to actually describe the product or a characteristic of the product. So when people hear those terms, they don't think of where the product comes from, they think of the product itself. And so those types of marks would not be protectable. So an example would be, and sometimes these words were trademarks when they began, but they've become genericized through over time. So like escalator is one example. That was a trademark of a company early on, but people refer to an escalator now. It's the noun. It's not the adjective that describes the noun. It doesn't describe the source of the goods. It describes the actual goods themselves. So those types of marks are not protectable. As you move farther along the spectrum, you have marks that are called merely descriptive marks. And those marks also describe the goods, and without more, they're not protectable. But where they differ from generic marks is that if you have exclusive use of a merely descriptive mark for 5 years, you've acquired distinctiveness in that mark. And therefore, you can register at that time. So it may take some time to get those merely descriptive marks registered, but in some instances, they can obtain registrability.
Yeah. So what's the process look like of getting something trademarked? I know there's like registered trademarks, and then there's like non-registered trademarks where you're trying to build.
Right, right. So the process, it's a pretty straightforward process. You would have to initially identify the mark that you want to apply for, and then the goods and services that you would want to use that mark with. And then we would fill out a pretty straightforward application that we submit to the U.S. Patent and Trademark Office, and then they review it. It typically takes 4 to 6 months once we submit it to hear back from them. And then once it's approved, it gets published to give any other third party the right to voice their concern over your mark. They might feel that you're getting too close to what they're doing. And if no one objects during that publication period, which lasts for 30 days, then you have to submit a specimen showing your use of the mark, so that there is a use requirement for registration. But then once you submit that and it's accepted, then you have your registration. And the marks that would be the strongest marks, kind of continuing along that spectrum conversation, would be suggestive or fanciful or arbitrary marks that don't describe the good, but could be identified as source identifiers by consumers, where the goods come from.
Okay, got it. So you got to go through trademark probate.
Exactly.
Essentially.
Yeah.
Use it, make it very clear that you're using it.
Right.
And then that's part of the process.
Right. And on the flip side, that's looking at it from the standpoint of someone who's applying to register. But if your competitor tries to apply for something that's too close to what you're doing, maybe they're trying to trade off of your what you've built up in the marketplace. During that publication period, we can file what's called an opposition and oppose their application to protect you and make sure that, because trademark examiners at the trademark office, they're human too. They things are going to slip through the cracks, and it could be that you haven't applied for registration. You've just been using the mark for the last 50 years, and so the trademark examiner may not see that, and so but you would have superior rights potentially to someone who just applied today, and so we can help clients in those situations to maintain that exclusivity through the opposition proceeding.
Okay, so like having actually practiced with a certain image for 50 years, like you said, and maybe not gone through the formal process, but like somebody's clearly trying to infringe on your brand or like, suck some of your goodwill out of the marketplace. You might still have some hope of reclaiming that. So
if you have been using a trademark in commerce exclusively for a period of time, you begin to develop common law rights in that mark.
Mm.
So an example of this would be, I'm sure you've seen trademarks with a little TM symbol
Right.
next to it. So
Absolutely.
those types of marks have not obtained federal registration. Federally registered marks have the circle R
Yep.
next to them. So the two symbols that are used are TM and circle R. And the TM symbol could be a mark that's been used for a long time, but just was never registered.
Mm-hmm.
But through the use of that TM symbol, they're putting the public on notice that they're actually using that. They intend to have that mark as their source identifier and as a trademark. And so their protection would extend to whatever geographic region they've been using the mark exclusively. And so the more you use it, the more protection you can potentially claim.
Got it. It seems like, kind of going off script, it seems like in today's day and age, you can actually achieve like distribution in a larger geographic area a lot quicker just because you're using like the internet and stuff
Sure.
like that, right? So that, yeah, okay. Interesting. Okay. And so how long is your typical trademark good for? Is it good indefinitely? You have to continually renew it?
Yeah, it can be renewed indefinitely. When it registers, it's registered for an initial 10-year term.
Yeah.
Although you have to file some paperwork between the 5th and 6th year to get the full benefit of that 10-year term. But then it's renewable for 10 years as long as you keep using it.
Mm-hmm.
So the idea is that the government, if you're not using the mark, they want to, free it up and let other people use it. And so that's why you just have to keep using it. As long as you keep using it, you can claim exclusivity to it.
Yeah. How about so like some of the other topics like cyber squatting or like kind of people trying again to infringe on a brand that you already have.
Yep.
But so like if you have a specific name or something that you came up with that specifically describes your product or your company, right? And then somebody goes out and buys that URL .com, right? Which everybody wants the .com. They don't want the
exactly.
Yeah.
Yeah. So it would depend on the specific facts and how broadly you're using your mark and whether they're using it for different goods and services and the intent that they why they adopted that mark. Are they trying to sell? Are they an innocent adopter and selling
Mm-hmm.
on completely different goods and services than what you're doing? And in that case, it might be tough to go after them. But if it's someone who had the intention of trying to harm you and they're selling the same thing as you are, then yeah, you're going to have a better chance at going after them and trying to shut them down or have the domain transferred over to you. So it would just depend on the specific facts at issue at that point.
Interesting. Okay, very good. And then so from a complicated topic to a more complicated topic, right? Which are patents.
Right.
Patents are way more complicated than a trademark is, right? Because you have two different types of patents usually.
Yeah. So primarily you have utility patents and you have design patents. There's also a third out there called plant patents that I personally have never prosecuted a plant patent application, but it's out there. Don't want to completely exclude it. But yeah, most of what my practice includes are utility patents and design patents.
Okay. And then so a utility patent is about what something does, like its specific use or?
Correct. Yeah. It's what it does as opposed to a design patent, which is directed toward the ornamental look of a particular product. So while a utility patent may claim a specific structure, it's not necessarily limited to a particular ornamental look. You can change the shape of a door handle, for instance.
Yeah.
And a design patent may claim a specific shape or configuration of a door handle. So. Okay.
Yeah. Design patents sound like 3D versions of trademarks. Am I like off base there?
There can be a lot of similarity. The primary distinction would be with a product configuration trademark, you are protecting a specific look that consumers identify with a particular company. But you don't need to have that consumer recognition for a design patent. In fact, we would encourage clients to file their design patent before they've entered the marketplace at all, to maintain that novelty and to give you the ability to seek foreign protection, because in a lot of foreign countries they require absolute novelty prior to filing. So if you go to a trade show, for instance, and disclose your product configuration or your design patent idea, there may be the ability in the United States, there's a grace period that we can try and file in, but internationally you would need to have absolute novelty in most cases.
Okay, yeah. So design patents were a little more obscure to me. So
Okay.
I kind of went on the internet and I looked at a couple different ones.
Yeah.
So like, like I guess the casing of like an iPod Shuffle, right? Nobody can ever replicate that as
Right.
long as the patent's out there.
Right.
Or the funky look of those Croc shoes, right?
Right. Right.
Yeah. So that's not utility, because shoes have been around for ages and ages, right?
Sure.
But the exact way that they look
Right.
would be, yeah.
Yeah. So if you wanted to try and get around the Croc design patent, the Croc shoes are very round and they have a very,
Yeah.
distinctive look. If you had something that was squared off, and had a bunch of right angles and sharp edges and things like that, that would, you'd have to go in that direction to try and get outside the scope of what I'm envisioning. At least I don't have the Croc patent in front of me, but maybe they've tried to broaden their
Everybody has
portfolio.
everybody has a pair in their closet. Let's admit it. They're super comfortable when you're taking the kids out to Disneyland, right?
Well, that's what my friends tell me.
Exactly. All right, really good. Okay, and so again, how novel or how simple or how intricate does something have to be in order to qualify for a patent? Can you just improve on something, or?
Yeah, so there's two main thresholds. The first one is that it has to be novel, meaning it's never been done in the history of the world before. So that one is typically an easier threshold to meet, because if you make just even the smallest distinction or improvement on something, you're going to reach that novelty standard. The tougher standard to meet is what's referred to as non-obvious, that your improvement to what's already been done before has to be a non-obvious variant from the state of the art. And so that's where a lot of our time is spent, is in arguing with patent examiners over whether a particular idea is obvious or not.
Yeah.
So it, again, would depend on the facts of the case and depend on the state of that technology at the time the invention was made. But it needs to be more than just a minor variation or a minor tweak on what's already been done. Got
it. Okay, so like everybody has one of these things, right?
Sure.
Or like this
water bottle.
It's a water
thermos.
It's a thermos. Yeah, exactly, right. So I'm holding up a hydro flask right now, right? A 750 milliliter hydro flask. And so everybody had that kid in grade school that used to come with the thermos, and they had their soup in the thermos, and or their dad worked construction or something like that, right? And so this is just kind of a new take on a very old concept, and then they have all these varying tops and stuff like that, right? So is that utility? That's more design? What do you think?
Well, you could try and protect it both ways. So obviously, like you said, the thermos, there's nothing new about the general concept of a thermos.
Right.
But the way that the mouthpiece may articulate, or where it's positioned and how it may lock in two different positions, or interface with some sort of straw or suction mechanism, those types of details might be something we can look at from a utility patent standpoint. But from the design patent standpoint, if that flask has a unique shape to it, it could be something that we could consider for design patent protection.
Okay. And then patents, physical goods, mechanical goods, software programs.
Yeah,
kind of.
That's a very dynamic area of the law right now.
Yeah.
And so it depends on, again, the nature of the software and the specific facts, and how complex it is, and what the functionality that it's performing. But it's something that would definitely look at. But yeah, you covered a good list there of what would fall into patentable subject matter. But also something that could be considered is our methods. So if you have a unique manufacturing method or a unique method of creating something, that is also something that we can apply for patent protection. And a lot of times we try and protect an idea from both the structural standpoint from a utility patent, but also maybe how it's made. So if you have a main competitor that manufactures the product, we can shut down the actual process of manufacturing. And then if it has a unique look, we can protect it from a design patent. And so we may try and have several different layers of protection to make sure that we have all options available when it comes to maintaining that exclusivity for the client.
Yeah. So what area do you primarily work in?
So yeah, my technical background, as a patent attorney, you have to have a technical background in addition to your law degree. So my undergraduate degree is in mechanical engineering. So I deal a lot with mechanical type inventions, whether it's infant products or some things in the automotive industry. Medical devices would fall into those types of things. Golf products, sporting products, things like that. So that's where a lot of my practice is on the patent side. But the trademark side, it can be really, it varies across the board. Wearing apparel companies are obviously pretty big because they want to protect their logo and their brand. But it could be anything from tax preparation professionals to high-tech companies. Obviously, when we work with a company on the patent side and they're ready to bring that product to the market, we also work with them to protect how that product is going to be branded. So we try and hold ourselves out as the full gamut IP attorney, where we can help them from the beginning, the inception of that idea, all the way to bringing it to the marketplace.
Okay. This area of the law is like super technical, right? I mean, like I've had clients in manufacturing. They've developed new products, and the write-up hasn't been exactly clear, or it didn't have everything. So it's really important to go to somebody who specializes in what it is you're trying to accomplish, almost, right?
Yeah, exactly. And you want to make sure that they have the right technical background as well. Yeah. Because it's the devil's in the details when it comes to this line of work, and there's a lot of time and thought that goes into each and every word that is put in the patent application, because if you need to enforce that patent 10 years down the line, and it's going to be read in front of a judge, it's going to be read in front of a jury, it initially has to pass the scrutiny of a patent examiner. Right. So there's a lot of different people that we have in mind when we write that patent application, and trying to appeal to all those audiences, with the primary objective of obtaining as broad a scope of protection for our client as possible that's going to be enforceable and survive the scrutiny of all of those different audiences. Yeah, and time and technology is constantly moving forward. You almost have to predict the future, which I guess an inventor is doing anyways, right? But and the law is constantly changing, so there's a lot of moving targets, but that's what makes what we do challenging and fun. Okay, and then when you're submitting a design patent, is it all written, or are there actually drawings, maybe some blueprints associated with that as well? With a design patent, it's almost exclusively drawings. Okay. There's a little bit of write-up to describe, using the example of your hydro flask. Yeah. We would call it a thermos or something, and then it would just have several pages of drawings showing the thermos from different viewing perspectives. From the top, how does it look? From the sides, how does it look? From the bottom, how does it look? From an upper perspective, lower perspective, those sorts of things. That's going to comprise the substantial majority of a design patent, compared to a utility patent is going to be a bunch of drawings in combination with a pretty extensive write-up describing the idea. How long can you protect a patent usually? For a utility patent, the general rule is 20 years from the day you file it is the initial patent term. in order to keep it enforceable throughout the entirety of that term, you have to pay maintenance fees at 3 different points. But yeah, 20 years is the general rule. And for design patents, it's 15 years.
Okay. Yeah, I heard something like if it's so, it would be harder to enforce a patent, like if you came up with something that was so important to the public that, like, you couldn't withhold it from the public. Is that making any sense? Like, like something that, I don't know. I mean, I guess like
like a new pharmaceutical
yeah,
drug
well,
or
I guess like
something?
drug companies do it all the time, right? So like if somebody came up with the cure for cancer,
Right.
or somebody, I don't know, I guess that's still enforceable, right?
Yeah,
they do it all the time.
I think the flip side to that argument would be that
Yeah.
the patent system was created to incentivize companies to come up with the cure for cancer.
Right.
Give them dangle a carrot in front of them to spur that innovation.
Mhm.
So the way the patent system is set up is inventors come up with those ideas, and through the patent application, they have to describe that idea so that somebody else can read the patent and then be able to make that product or create that drug.
Mhm.
And so there's a limited term that company would have exclusivity.
Yeah.
But once that term's expired, then the public, anyone can practice that invention. And that's why you see generic drug companies come in and start manufacturing the drug at a very low cost once the original patent that covers the drug expires.
Yeah. And then also in the drug world, it takes so long to get something like FDA approved, right? That like your patent can be almost worn off by the time you go to market.
Yeah, there's, since I'm on the mechanical side, I don't have to.
You don't have to deal with that.
I don't
okay.
have to deal with
All
that too much.
All right, never mind.
Yeah, but you're right. The FDA approval process it does take a while.
Your firm's has like about a dozen attorneys.
Yeah.
And so each of you kind of specialize in a few different areas, right?
Yeah.
You probably have a drug guy.
Yeah, we have a drug guy.
Yeah. that you can kind of bring in for stuff like that. So.
Exactly.
Yeah, cool.
Exactly.
All right. So, what else can you share with us today? Is there anything that, I haven't covered, or I kind of
No, I
highlights.
think the only other part that that fits in with our practice is the enforcement side.
Yeah.
That once you've acquired these rights, we can help clients to make sure that they're being respected in the marketplace.
Yeah.
And so, hopefully it's a pretty simple process. It can be as simple as just sending a cease and desist letter and hope that whoever receives that letter respects it and complies with what we're asking.
Mhm.
But if we need to take legal action, initiate a lawsuit, then we're equipped to do that as well. So enforcement would be one thing, and then just keeping in mind that a lot of these rights extend only within the United States. So if you have markets abroad,
mm-hmm.
and you want to sell your product internationally, we can work with clients to seek out protection in those foreign countries. And so we have a network of foreign associates that we work with throughout the world to extend the protections that we hopefully get in the U.S. to those foreign jurisdictions, whether it's the European Union or Japan, China, Australia, whatever country or jurisdiction the client believes that they're going to be selling in.
Yeah, that's a good point, right? So because just like thinking about Apple and iPhone, like Apple's sued Samsung so many times for stealing their ideas and going to market faster.
Right, and vice versa.
And vice versa, yeah. And then there's stories about Chinese manufacturers like running the plant overnight and producing replicas of the systems that they're supposed to be, right? So that's a huge part of the law as well. Yeah.
Yeah. So when it comes to a U.S. patent, it would cover anything that any stream of commerce that touches the U.S. So if you manufacture it in the U.S. and then you ship it abroad, which is a very, that's kind of a backwards
we don't do that
approach.
much.
Yeah, we don't do that much. But if that were the case,
then
or your competitor did that, then that type of activity could, the U.S. patent would cover that type of activity. Or if you ship it, if it's manufactured abroad, it's shipped to the U.S. and then is shipped out into Europe, even if it's never sold in the U.S., that sort of activity could be covered by the U.S. patent. But if your product is manufactured in China and then shipped to Europe and sold in Europe, then you would need either a patent in China or a patent in Europe to protect yourself with that sort of activity.
Yeah. Okay. Starting to wrap it up. I think it's really important that people get educated in this area, and that these protections are available, and then also look at like what they're doing on a day-to-day basis, if they're actually making any improvements, right? So
Right.
a lot of my clients are physicians or dentists. They might be improving a process that that would be good for the marketplace, right?
Absolutely.
And so they should look internally, see if they're doing that, and see if it's a novel concept that other people would that'd be worth to distribute to other people. And so that's something. Also, people in construction, people in manufacturing, right?
Right.
Constantly tweaking processes to make things simpler, faster, better, more efficient. And so that's really tying right into your practice.
Exactly.
Yeah.
That's exactly right.
Okay.
Yep.
Awesome. What else? Anything else? If not, we can kind of wrap this thing up.
I think that's it.
Where do people find you?
I work at Stetina Brunegard and Brucker, which is a mouthful, as you encountered at the very beginning.
Yep.
But our office is in Aliso Viejo.
Okay.
And our website is statinalaw.com, and you can find us there, or you can find me through Gabe.
All right. Sounds good. I'll put my info out there too.
All right.
All right. Thanks, Mike. I appreciate you coming on the show. It was fantastic having you.
I bet.
All right.
Great being here. Thanks a lot.
Bye.